There's a big win in court for a former NFL star who is facing murder charges. A judge ruled certain evidence will not be allowed at the murder trial of former New England Patriots tight end Aaron Hernandez. Hernandez is still awaiting trial, accused of murdering Odin Lloyd. Happened in Boston in 2013, and now prosecutors will not be able to mention a couple of other slayings allegedly committed by the former New England Patriot. The defense argued that it would be prejudicing the jury against their client. But perhaps the most surprising here is the judge threw out a text message Odin Lloyd, the victim, sent to his sister shortly before his death. Prosecutors say it showed Lloyd was afraid for his life, and it says, quote, "You see who I'm with? NFL," apparently referring to Hernandez. "Just so you know," he wrote. Let's bring in criminal defense attorney and former prosecutor Philip Holloway again joining us. Thank you for being here. First, I mean, how does this impact the case?
Well, it hamstrings the prosecution to a certain degree. Obviously, the text message, they would have loved to got that in to show, you know, this guy was afraid of his attacker and he's letting somebody know who he's with.
Why can't they use the text message?
Well, I would respectfully disagree with the judge. I think that it would be admissible. I think it's relevant, and I think that whatever weight it might have should be considered by the jury.
She called it innocuous.
Right. Well, we don't know from looking at it exactly what it means, and I think that's what she's hanging her hat on. That being said, I do believe a jury should be allowed to make that decision and let a jury decide whether it has any weight and what it means. As to the other crime evidence, I do agree with the judge on that. We don't want to try people based on their general bad character. We don't want to try them on other cases that they might be involved in unless they are sufficiently similar. If two crimes are so closely related and similar that it shows their modus operandi, sort of somebody's criminal signature, if you will, then the law would allow that evidence to come in.
Well, I mean, from an outsider's perspective, looking at these different cases, it does seem to me that they would be similar. I mean, we're talking about in 2012, a double homicide, somebody who, you know, shot and killed these people, and he is the primary suspect in that case. He's also accused in another shooting in 2013 where the victim survived. They all involve Aaron Hernandez. They all involve some kind of violence using a gun.
Well, they allegedly involve Aaron Hernandez.
Thank you. Yes, allegedly.
And you're correct. Those are all the arguments that the prosecutor makes, but there's one overarching principle that the judge looks at. Does the danger of unfair prejudice apply here? And if bringing this stuff in is so damning, if you will, to Mr. Hernandez's case, it's so overly prejudicial, the judge has every right to keep it out.
And you said you agree with her decision, at least when it comes to those other crimes where he's a suspect.
Of course, because he's not been convicted. You know, she probably would be on solid ground if she let it in, but she's playing it safe by keeping it out. She doesn't want to have to try this case twice.
It seems like this is a big win for the defense. How does this impact the prosecution?
Well, certainly the prosecution wants to get this in because it's very, very powerful. If a jury hears that somebody's involved in another murder or allegedly involved in another murder, it makes their job very easy to convict. So it is a huge win for the defense. You never want to allow prior crime evidence to come in from a defense perspective if you can help it, because it's so prejudicial to your case, and it just makes it very, very difficult to win an acquittal if the prior crime evidence comes in.
All right, Philip Holloway, thank you so much for being here.
My pleasure.